Honorable Swart, it's your turn.
Chairperson, thank you, and Dr. Fine, thank you for coming, and thank you for not bringing a bank of lawyers and for coming and answering our questions. Obviously, you can understand our discomfort with McKinsey, particularly when one looks at the Budlender report, when one looks at other issues. One of the points you made was why McKinsey didn't respond to the Budlender was it was information about clients, and you used the plural. But I've looked at the questions, and most of it related to Trillian itself. So if you can explain to me, because you've got Budlender representing Trillian, asking you about Trillian, why wouldn't there have been a better cooperation? And yes, you've indicated now that you should have cooperated, but looking at that stage, there was a lot. In hindsight, one is better, but clearly there was a lot of hiding away of information and keeping it away from a Trillian investigator.
Good. I have a sweet in my mouth, so if it sounds a bit strange, hopefully it's fine. So let me start off with this.
Yeah, you can. We have a right to pause a little bit.
No, I'm good.
Okay.
I'm good. Let me first start. The letter that you're referring to is a letter from McKinsey to Eskom. So it is not correct to say that this was only between, let me call it, Trillian, and it was a letter that was addressed. So having said that, I'm not going to sit here and try and defend McKinsey's behavior and action with Budlender, because I think we should have just met with him and had a conversation, and it would have been a reasonable conversation, and he's a highly respected advocate who has the highest ethics in this country, and we should have just had a meeting and resolved this. I think one of the other factors that probably came into the discussion, but I wasn't part of them, was at least by the time the Budlender matter was happening, there was a lot of information that had been put into the public domain by regiments and Trillian as part of some court case that they had and was being litigated, or at least was certainly a lot of press around this. So I am not sure what the considerations were. Mr. Budlender is a well-regarded man. We should have met with him and had a reasonable conversation with a highly regarded man. And that's all I can say. I mean, my understanding was that was one of the concerns.
Yeah, it's in hindsight, but that's now. That's 29th of June this year, with all the information, that there was a very clear lack of cooperation, and you've apologized and said there could have been better cooperation, and I accept that. But if you also look at the response in that report of Ms. Goodson, and you've reported that Mr. Lawrence Jungelin's comments about the 30% is unacceptable against all your values, but she says on paragraph 106, in response to I think it's Mr. Jungelin, that says, it doesn't really matter as long as you get your percentage, all right? She said that this was in response to her complaint that McKinsey was not engaged in Trillian in the program, and that's a supply development program, with the result that Trillian was not receiving the exposure and experience it required. She reported that a general theme from the McKinsey leadership down, so this is not only Mr. Jungeling, from the McKinsey leadership down, was that Trillian as the development partner is simply a necessary but unwanted piece of baggage in the awarded contract. Now that's scathing. It's not just, by the way, there are two aspects. Firstly, that it's very clear that Trillian was part of the contract and the deal, not legally, but it was part of the package. And secondly, of course, that it was an unwanted, it was basically get your 30% and we'll be happy. Now you have, just to me, it's not only Mr. Jungeling that was involved, and you obviously were not involved, you've said that, but there seems to have been leadership at McKinsey as well that had that view. Are you able to comment on that?
I'm not, but there are two additional pieces of information that I've read, and I can't remember where it was, in the press or as part of an affidavit, etc. One was that Trillian and Ms. Goodson participated in steering committee meetings at the client, that there were extensive discussions, and she would have participated with them, and that secondly, after those comments were made, that she raised her concerns, and if I recall correctly, the adjustments were made, if I recall correctly. So I therefore making the assumption that when those statements, I can't explain them. What I would say, which is, and I can't speak because I was not observant, an observer there, but there are also inconsistencies in some of her testimony, and I'm not saying that therefore her testimony is not correct, but if you look at the letter which is in the annexure here, Annexure F, where we wrote and asked her about, we asked Eric Wood about Mohammed Bobat and his connection to the, to the Africa Confidential article. And there's a letter in the Appendix F here from Ms. Goodson, which basically says that there's no connection between Trillian and Bobat at all whatsoever, and yet at the same time, there's additional information that says Ms. Goodson was meeting with Mr. Bobat and Oliver Wyman with Mr. Van Rooyen. So I hear you, and I'm not trying to defend, and I'm definitely not trying to undermine her testimony, which I think she stated on the record, and I have to take it at face value. But at least my sense is there's more in that than just the simple statement.
I appreciate that, and that's part of this process, is to engage with all evidence that we've received and test that. Doesn't mean we accept everything that is said here if we hear, and that's why those people that are implicated will be given the opportunity to come and contest what has already been put before us. So there's no problem with that, and that's helpful. The Ms. Mutepu, who is CEO of Trillian Financial Advisory, she, in her affidavit, speaks about the 600 million that was paid to Trillian by Eskom, and she says that she is willing to assist Eskom to recover the fees it paid to Trillian. Now, we're very grateful for the fact that McKinsey is offered to repay that 1 billion, and we hope Eskom and ourselves are able to assist the National Treasury to finalize that without the usage of any more consultants and further fees. That's a massive concession, and again, it's not made by any admission of liability from your side or admission of wrongdoing. I appreciate that. But here you've got the issue of the payment now to Trillian, where, and it's nothing to do with you, but it just indicates the relationship, McKinsey, Trillian, and Eskom, where she says the payments made to Trillian. I'm of the view that these payments were made in contravention of the PFMA and the Companies Act. Now, that's criminal action, plus civil action, but criminal action, and are therefore unlawful. In addition, I do not think the fees that Eskom paid Trillian were reasonable to the value it created, as much as the work Trillian performed could have been performed by the internal Treasury division of Eskom. Now, I appreciate regiments might have done a lot of work, but we seem to see that Trillian, a lot of the work it did was either done by regiments or was not done at all, or could have been done by Eskom. Are you able to comment on that at all?
I'm not able to comment on that because I don't know what work they were doing. Suffice to say, from McKinsey's perspective, and I was on the phone with our global legal counsel last night and said, I'm coming into this meeting. I want to have comfort that on the basis of our investigations, if we uncover issues, that we will file the relevant submissions to the authorities in this regard. I also, as I said earlier, spent some time with colleagues to try and understand whether or not there was value from the work McKinsey did. And I don't, and one always has to be careful because I can throw out numbers and everyone will say, well, those are big and maybe it was a tenth, whatever. But I got comfort after those discussions that there were benefits that could be measured which would at least explain the fee. I'm not saying, therefore, and I reiterate again, I'm comfortable with the size of the fee, that Eskom could have actually absorbed this much change, but I have got comfort from my colleagues, at least what they've shown me, and has been independently audited by Oliver Wyman, that was value. Whether or not Trillian, 600 million, what they did, whether that was reviewed, for what benefit, I can't answer that question, unfortunately.
Just ask you then, in your statement, page 11, where you speak about the 1 billion rand fee, and you indicate there that you didn't think that Eskom had the management capacity for the 11-month work. If you just check on that page, because I don't want to misunderstand you. So in other words, you were, the consultants, 100-odd consultants were busy doing work, plus work that would go forward if Eskom management implemented that. And is that what you say under C? Even though the fees were an agreed percentage of savings and the benefits to Eskom were large, are those the benefits in the long term? Surely that would be, or are you saying the 1 billion rand was the fee only for the 11 months work, or was it benefit to Eskom as well? Because I'm misunderstanding you slightly there, because to me it's a very exorbitant fee, and that's why you said we should have kept our fee structure. So I'm not so sure that value was received, although an external consultant says, Winan says it was. But you are saying here that in hindsight you should have kept the fee, the benefit going forward. Is that captured in that 1 billion rand or not?
Well, let me give you one example of some of the information that was given to me. The fact that we'd worked on with some of the generation facilities and improved availability meant that 8.4 billion rands worth of diesel costs, which we were burning, if everyone remembers, in 2015, were reverted. Now, if you said to me, is that going, is that number, can I stand behind it because I've seen it and done the calculations? I haven't. Is it half of that, quarter of that? Doesn't matter. If I compare that to the fee, I would say, I can stand here before you and say that, there was benefit. And that was one example. And there were others. And I don't want to go through that because I don't have comfort at this moment in time. What I would say to you, though, is one of the challenges McKinsey was going through is because of the significant resources we'd had on the ground, and you could say that was your own choice, McKinsey. The way in which we came into the commercial negotiation was from a very conservative perspective, meaning that we wanted to make sure that we got paid because we'd already invested substantial resources on the ground. As a consequence, if you look at the way those benefits are measured versus how I would have liked them to be measured, it's harder to explain to the South African public that one-to-one relationship. So I would have had, and that's one of my reflections, a much more detailed gate process where we would have been paid on the flow from idea to proven, to plan, to delivered, to income statement. And that was not in place at the time.
What I'd like to just quickly comment in my remaining time is the locomotive transaction, and where you were involved in the process as McKinsey with Transnet. Up to a certain point, the calculation was 25 million for a diesel locomotive and 34 million for an electric locomotive, and then you got to that figure of 38.6 billion over a 7-year period. We now know it's the 54 billion over a 3-year period. That was in 17th of March 2014. So we've got almost a 15 billion rand difference from what was quoted then. And you spoke about hedging. There could have been a bit of a difference. Mr. Gordon asked you about that. But when you engaged with Mr. Singh, he said, that's Mr. Anish Singh, is that correct? Mr. Singh said that Transnet had done new calculations based on funding costs, exchange rates, and had come to the conclusion that it was better to secure the deal they did. Now, we also know from the outer documents that Tequestra entered the Chinese deal for the fifth, and suddenly the locomotive contract is 50 million rand per locomotive, of which 10 million rand is a basic commission payment kickback. We also see a contract. Have you had sight of this document, the documents from Amu Bangani Outer, the contract with the locomotives Tequestra and China South Rail? Have you had sight of that, and does that explain at least a 5.3 billion rand increase in the contract fee that you initially thought was viable to that increase of 15 billion, at least part of that, and that was for 300 odd locomotives.
So I have read those articles, and I had not seen those numbers before I read the articles, and that is absolutely possible. That could explain the difference, and I think that's exactly what the committee needs to do. I think you need to take those facts, and you need to understand how I can tell you how the locomotive costs per locomotive were established in the business case. And that,
Just keep it brief because my time is almost up. Thanks.
Number one is it was based on the price that Transnet had paid for a locomotive in the 18 months prior to when we were doing the project. So it wasn't just a number. It was based on actual procurement that had been done. It was adjusted for what inflation, etc., would be. And it was we also obviously had this man, David Potter, who was an expert on this. So I don't personally think that the 25 and the 34 were unreasonable numbers. I think the question that you need to ask Transnet is how do you get from 25 and 34 to 50, and how does this delta change? And I think they need to come and explain to you the differences.
I think, and we will, and this will be the second part of this inquiry, but what is astounding to me is this contract. And of course, those implicated can come and explain this contract, but it basically sets out a clause that allows for that 5.3 billion rand commission for the pure introduction of the parties, Transnet and South China Rail, by Tequesta, which is Salim Issa's company. And for that, he says, on this contract, and again, it can be contested, it is noted and agreed between the parties that the services, and this is advised in the deal and everything, are provided as a pre-project service, and will conclude on the company signing this contract. That's that clause is worth 5.4 billion rand. No services thereafter, introduce two parties and get 5.4 billion. And I agree with you that that is something we will be engaging when we look at the Transnet issue. So, Chair, from my side, thank you very much.